argument.
Bless you. Would you like to reserve any time for rebuttal?
I would. I'd like to reserve 5 minutes, please.
Okay. I will do my best to find a discreet and moment to not interrupt a train of thought to let you know. If I have to, I'll interrupt, but I'll try to get in there as close to that moment as I can. With that, the court is ready and you may proceed.
Thank you, Your Honor. May it please the court, I'm Daniel Norby from Schutz & Bowen on behalf of Fitness International. This is a commercial lease dispute between my client, which operates LA fitness gyms around the country, and Verit, its commercial landlord at the Tampa Palms Shopping Center. The dispute here arose from government orders prohibiting gyms and fitness centers from operating for a period of weeks at the beginning of the COVID-19 pandemic, and whether my client's rent obligations were excused by the force majeure provision of the party's contract or any equitable defenses to contract performance. I'd like to begin the argument today by acknowledging the decisions issued by this court and by the third DCA in mid-May, about 3 weeks after the briefing in this appeal concluded. The third DCA's decision in Verit versus Fitness International that Ms. Anderson and I had the pleasure of arguing against one another, and this court's opinion in Fitness International versus 93 FLRPT each rejected my client's arguments under both the force majeure provision and the equitable doctrines. So given the adverse prior panel precedent from this court, I'd like to spend my time today, unless the court prefers otherwise, discussing why some aspects of those decisions may warrant additional attention either by this court sitting en banc or by way of a certified question of great public importance to the Florida Supreme Court. So I'd like to start with the force majeure arguments. The contract interpretation arguments regarding the force majeure clause in this contract are set out at length in our briefs. I'd largely rest on those arguments, but want to make a couple of brief points in opposition to the interpretation adopted by the trial court here. First, the parties to this case stipulated that both the COVID-19 pandemic and the government orders making it illegal for LA Fitness to operate its gyms in Tampa were, quote, restrictive laws that were beyond the reasonable control of either party within the meaning of the force majeure provision in the contract. The second sentence of the force majeure provision here, which was the subject of some dispute and interpretation here, we'd submit is more reasonably read to emphasize that an inability to pay cannot itself be a force majeure event excusing performance. Of course, my client, Fitness International, has never claimed an inability to pay. That's not the force majeure event that we identified under the contract. It's the restrictive laws, the government orders prohibiting the operation of gyms and fitness centers. Our reading, we'd submit also, is consistent with the first sentence of the force majeure provision, which identifies, quote, financial inability as an exception from the definition of a force majeure event. The trial court's reading here renders the force majeure provision essentially one-sided as to the obligation to pay rent and fails to consider the mutual obligations of the two parties. Under the interpretation adopted by the trial court here and advocated by my friend on the other side, there would be no event, no force majeure event that would ever excuse the payment of rent by my client here, because it's simply a truism that the non-payment of rent can be cured by the payment of rent. So there would be no circumstance, no length of time that my client's unable to operate its fitness facilities that would ever excuse its obligation month after month to continue to pay rent no matter what. We've contrasted the Arizona decision that was filed as supplemental authority here, also between Fitness International and Verit, in which one of the leases that the Arizona court discussed had what we've colloquially called a hell or high water provision, which added to the language of this force majeure provision an additional sentence saying that nothing in this force majeure provision, and I'm paraphrasing here, shall ever excuse the obligation of the tenant to pay rent under any circumstances. That language is not in this force majeure provision. We cited the 11th Judicial Circuit opinion from Miami that contrasted the inclusion of that sentence in the Arizona lease and the exclusion of that sentence from this lease as an example of how the parties to this case know how to specify explicitly that that the payment of rent is not excused by force majeure events, and did not do so in this case.
Mr. Norby, can I interrupt you for a second? I feel like I've got to, at least to speak on my own behalf, I feel like I've got a pretty good handle on the interpretive arguments here. I appreciate you acknowledging our FLPRT decision that came out not too long ago. Does seem to, I mean, I did a side-by-side comparison of the two force majeure clauses. They look pretty darn similar. So I'm curious about your kind of how you led in with that, which is you'd like us to consider this possibly raising a question of great public importance. Always open to that idea, but I will tell you in all candor that I haven't been a judge for a huge long time, but I've been one for a little while now. And before that, I did business litigation for a time. And I got to tell you, this is the first time I've ever had a force majeure case. So is this, help me flesh out the public importance here. I get it's very important to your client. I totally get that. But in terms of how this affects the broader public, can you help me through that, given my admittedly limited background?
I'm glad to. Thank you, Judge. So there's frankly a dearth of appellate case law in Florida addressing especially the equitable doctrines that we've cited in our briefs here. Both sides are citing to the same 4 or 5 district court opinions, mostly from the 1980s and 90s. And all of those opinions appear to turn on the specific factual circumstances, whether it's a premarital settlement agreement or a commercial dispute. What we don't have in Florida is Florida Supreme Court case law from a doctrinal perspective on these equitable doctrines, when they apply, when they don't apply, in a manner that can be interpreted broadly across a range of things. As you've seen from the briefs, my client and the appellee here have been litigating this case around the country. We're not the only ones. Landlords and tenants have been litigating these force majeure issues arising out of COVID orders all over the country. And it's not just limited to lease disputes. I know this court has encountered the similar arguments in the case of university tuition. And, there's some different wrinkles to that, but other district courts of appeal have also encountered that. And I'd submit that there's other cases pending in the trial courts around the state too that would benefit. And I think the bench and the bar would benefit from a well-reasoned opinion that addresses these issues more broadly than the specific circumstances of the party's case, that would provide some guidance for how these issues are to be addressed. Just as one example of that, there appears to be in the 3rd District's decision and in this court's decision involving my client, a presumption that if the parties to a lease include a force majeure provision in their contract, then that necessarily means that force majeure events are therefore foreseeable, and perhaps equitable doctrines are entirely precluded. The courts don't get to the question of whether the equitable doctrine applies and whether all of the elements of the equitable doctrine are satisfied in a particular case, because the occurrence of force majeure events generally is foreseeable and is governed by the party's contract. I'm not sure that that's necessarily a correct statement of the law if you look more broadly at the equitable doctrines, how they're applied in other courts, and the very nature of equitable defenses, which is that they're intended to step in when unforeseeable events happen that are not contemplated by the parties. We cited the Equitrack case from the 3rd District Court of Appeal, as well as the Marathon Sunsets opinion from the 3rd District, that talk about the equitable defenses discharging parties' obligations, where neither party assumed the risks involved, and where the circumstances after the occurrence of the event are, quote, vitally different from what should reasonably have been in the contemplation of both parties when they entered into the lease. Your Honor, in this particular case, while my client may have anticipated the occurrence of some events constituting force majeure events, in this lease in Tampa or our lease in Miami, perhaps hurricanes or fires or other things, maybe even changes in laws such as zoning laws. The occurrence of a law prohibiting the operations of gyms and fitness centers, we would submit is something that is well beyond what the parties would have contemplated. We included an affidavit in our summary judgment evidence at page 251 to 254 of the record that from an employee of Fitness International that I think makes a point that's probably pretty obvious. If Fitness International knew that it would be unable to operate an LA Fitness gym at the Tampa Palms Shopping Center for a period of weeks and months, it would never have entered a lease to do so. That would have been so far outside the contemplation of the parties that it cries out for the application of these sort of equitable doctrines. So, Judge Lucas, going back to your question, one of the arguments that we think is of great public importance is when do those equitable doctrines come into play here when the parties have addressed a certain allocation of risks under a force majeure provision? Does the force majeure provision automatically preclude any analysis under the equitable doctrines? This court in its earlier opinion also explicitly reserved ruling on a question of whether Florida recognizes the doctrine of temporary frustration of purpose. The court's opinion notes in a footnote that it had no need to address that dispute in its opinion because it resolved the case on other grounds. That's an issue that the appellee here has raised, is whether that doctrine, which is explicitly recognized by some other states under the restatement, should be recognized in Florida. So those are just two examples of the sort of issues that occur in this case and that this court could pass on in this case that would also apply more generally to these sorts of disputes among the broader bar and bench and public as a means of getting some clarity to this area of the law. So, Judge, I hope that answers your question of why this case involves issues beyond the specific narrow dispute of this party's lease in Tampa. It brings into play some broader questions. So I've had an opportunity now to discuss some of the equitable defenses and equitable doctrines that we've briefed here and that the trial court passed on here. As I mentioned, for frustration of purpose, we cited the third DCA's decision in the Equitrack case. The appellee here did not cite or attempt to distinguish that case in their answer brief here. We think it applies. We think that the equitable defense of frustration of purpose appropriately applies when the purpose for which the subject contract was formed became entirely frustrated under the circumstances of the case due to no fault of either party. We are not in any way alleging that Verit was at fault for the circumstances that happened here. I think that no party was at fault for the COVID-19 pandemic and the government orders responding to that in the early days. But in those unforeseeable circumstances, the equitable doctrines appropriately come into play, and that trial courts should have the ability to evaluate how those defenses should equitably resolve the allocation of obligations and duties among the parties. This court's decision in the Home Design Center case from 1990 is to similar effect. The doctrine applies where one of the parties finds that the purposes for which it bargained and which purposes were known to the other party have been frustrated by the failure of consideration or impossibility of performance by the other party. I think the purpose of this contract was well known to both parties. We've included the lease in the record starting at page 321 going all the way to page 440, and it's apparent throughout the lease that this lease was for the operation of an LA Fitness gym. Section 1.9 of the contract identifies a series of purposes for which this property could be put by my client, Fitness International. All of those purposes are, I would say, gym related. They had the ability to sell things related to their operation of a gym and perform other duties that way. There's even in the lease examples of the signage inside and outside the shopping center, and the signage says LA Fitness Gym, LA Fitness Fitness Center. So there wasn't any question that my client might be operating a grocery store or a takeout restaurant or some other use that they could have pivoted to in the early days of the pandemic. My client operates gyms and fitness centers, and that's the purpose that was clearly contemplated by both parties at the outset of the lease here.
Mr. Norby, while you're on that point, I do have a question if you could help me out. They do gyms, but how does section 8.1 and 8.2 and 8.3 impact the sole functionality of a gym? Because doesn't that allow a change in use? Those provisions?
They do. They allow, and I hope I'm answering your question, Judge. They allow my client to change the use, but I think that's a separate question from whether my client would have an obligation to change its use, particularly
That would be off the main analysis. That would be a collateral matter to address after we did the first analysis, in your view.
It would, and particularly under these circumstances, where, and when we included a copy of our force majeure notice in the record, it's starting at page 257. What my client was requesting here was the same thing it was requesting with landlords nationwide, essentially a continuation of the lease arrangement that would add on a number of months at the end of the lease term that would be paid for during any period of time that it would be prohibited from operation as a matter of law. So we think that frankly is a reasonable, equitable result under these circumstances through the fault of neither party here. But remembering as well,
we're at 15 now. I'm past it, but since I invited your comments, I'm not going to penalize you for that. But for an FYI, we've hit 15.
Okay, thank you, Judge. Let me just say one more brief point to finish that thought. That at the beginning of the pandemic, my client had no way to know how long these government orders would have been in effect. So the idea that they should have had to change their entire business model or try to sublease the space to someone else, as though anyone was subleasing commercial rent space in the early days of the pandemic, is we would submit not a reasonable expectation to put on the parties, given the reasonable expectations under this contract. So with that, if I have time remaining, I'll reserve the rest of it for rebuttal, but we'd ask the merits judgment and the fee award to be reversed or for an appropriate question to be certified as suggested.
Thank you. Stop the time. Okay. Attorney Anderson, I have cleared the clock, so to speak, so you don't have to worry about starting at the previous time, and you started at 0. So the floor is yours, and please proceed.
Thank you, Your Honor. May it please the court, Catherine Anderson of Ballard Spahr on behalf of REIT Real Estate LP. This case is one of many across the country where, with very straightforward facts, the government shutdown in Florida lasted approximately 3 months, and during those 3 months, fitness has refused, despite more than 2 years passing since reopening and full operation being resumed, they still refuse to satisfy their obligations from 2020. I understand the relief that fitness is asking here. However, the facts of this case simply do not support it. The facts here are that we had a 15-year lease. There was an unforeseen event that's been stipulated to and agreed to by the parties. No one expected the pandemic to happen, with the exception of perhaps Bill Gates. However, it happened, and there was language in the lease which accounted for restrictive laws, unforeseen events. The force majeure clause is very clear in section 22.3. It does discuss restrictive laws, and if there's a delay, hindrance, or prevention of performance of any act required under the lease. Financial inability is specifically accepted. Fitness does not claim that they were not financially able to perform, but what they are refusing to satisfy is a financial obligation. This provision of the lease would apply to delay certain acts under the lease. For example, section 12.2 of the lease provides certain maintenance obligations. Those maintenance obligations could be delayed as a result of the pandemic. Had fitness given a notice in the end of February 2020 that there was repairs needed, perhaps the time for the landlord to complete those repairs would have been extended past the 30 days that's provided for in the lease under this force majeure.
A question, because much like Judge Lippis, this is probably my first time with a force majeure clause. So I want to make sure that and the equitable thing regarding frustration of purpose. COVID, you have a stipulation, so it's a superseding or subsequent event that comes, and you've agreed that it was not reasonably foreseeable. For frustration of purpose, one of the elements is that the primary purpose of the agreement is substantially or totally destroyed by the event. The argument, as I understand from the appellant, is the purpose of this lease is to have a gym, and it was totally frustrated for at least a specific period of time. Whether or not we have to deal with the footnote issue or not, it's another one. But I'm wondering if that's one of the equitable things. Is frustration of purpose a legitimate concern that we should examine here?
No, Your Honor, because the purpose of this lease was not the operation of a gym. The purpose of a commercial lease between sophisticated parties is possession of property. It's a bundle of sticks.
Well, I
So-
thought the lease said it was for a purpose, that the building, and it had limitations because there were other contracts for this site, that it couldn't do this, it couldn't do that, it couldn't do the other, and it has maybe not the sole use, but a primary use shall be for the operation of the health club and fitness facility in 1.9. So it seemed that it may not be the only use, but everybody understood, so it didn't put the landlord or the owner of the property in conflict with other tenants, that this use had to be approved. So I'm arguing, I wonder, how does that work out? In your
Correct.
view,
So-
that I can get the benefit of both people who have spent a lot of time on this issue.
Definitely. Under section 1.9, those were the permitted uses and agreed upon uses, but that was not the purpose of the lease. But the purpose of the lease, if we look at 2.1, in consideration of,
A particular space,
I'm sorry,
is to rent in a particular space.
was to rent them the space. Then is language in the lease that says this is what they will use the space for. This is what they are allowed to use the space for, so that landlord can be ensured that it can abide by all its other contracts, and that it can make sure that all the proper permits are in place, the proper taxes are being paid. There's other ancillary obligations that have to be fulfilled. But just because there's language saying, okay, you can use the lease for these purposes, that doesn't mean that that's the only purpose. And in this lease in particular, fitness was allowed to go dark if they wanted to, without any without any consequence, so long as they paid rent. Everything in this,
The paragraph that you cite, is it then related to the provisions in 8.1 that indicate purposes can be changed, or the purpose section can be changed upon the giving of notice?
the paragraph that I
8.1, 8.2.
8.1 and 8.2, correct, to go to the changes in use that Your Honor mentioned earlier. And they do permit changes in use under certain circumstances, and it provides a procedure for how to advise that they'll change the use. And then there's also the provision that they're permitted to go dark as long as they continue to pay rent. What I would like to focus on would be section 2.1. In consideration of the rents agreed to be paid, landlord demises and leases to tenant the premises. So it was the property was the purpose of the lease. The purpose of the lease was to give
Well,
tenant.
it seems to me maybe the better argument is not just to say, here's the property, do what you want, but that the leasehold itself, if I remember, was like 15 years or something.
Correct.
Yeah, it's pretty lengthy leasehold. I think the better argument from my read is along the line of that, hey, at worst, you had business interruption for 3 months, and that's what business interruption insurance is for. You do not have a frustration of purpose of a 15-year lease, because you still got the property, you still have the leasehold for the majority of the leasehold time.
That's correct, Your Honor. The other important point there is that fitness never vacated the property, never tendered the property to the landlord. They continued to store their equipment there. They essentially closed the doors and then reopened several months later when the laws changed. So 3 months out of a 15-year lease, and numerous of the cases that we cited have said that this was not enough time to support a frustration of purpose argument. So if we look at the equitable doctrines, there's numerous reasons that those do not apply. First of all, this particular factual situation was contemplated expressly in the lease. And in fact, there are many provisions of the lease in addition to the force majeure clause where there are agreements as to if fitness would like to go dark, here's how that happens. If fitness would like to change the use of the premises, here's how that is done. This lease was very thorough, and it addressed all potential situations, because as we know, things can happen that no one expects. And even the force majeure clause, no one expected riots or war or the other items that are specifically spelled out in there. But it's a broad clause that incorporated these agreements. So the force majeure clause itself, the fact that the express language of the lease addresses what could happen under these particular circumstances and what ultimately did happen, negates application of the equitable doctrines. Further, even if that weren't the case, the facts here simply don't support application of the equitable doctrines. Fitness repeatedly in their briefing and in their argument at the trial court said, attempts to say that landlord's position is that if the gym was never permitted to open, never operated one day, that rent would still be due. Those are simply not the facts here. I don't know what landlord's position would be under those facts because they don't exist. Our only facts here are 3 months that the gym was unable to open, and that is not a frustration of purpose. The purpose of the lease was for Fitness to have the property. Fitness remained in possession of the property, continued to occupy the space, and resumed operations shortly after the restrictive laws were lifted. So there's just not, simply the facts do not support application of the equitable doctrines here. One quick point I'd like to make, Your Honors, is the reliance on intent. This issue, the terms of this lease are what the terms are. It would be inappropriate. The trial court did not look to the intent of the parties, and it would be inappropriate to look at the intent of the parties because these are freely transferable commercial leases. In fact, in this case, the current holder of the lease, I don't believe was the actual party to the lease. And comparing this lease to other leases between the same parties or different parties is not appropriate where the leases have been transferred. We can't look at the intent at the time the leases were executed. We have to focus on the plain language of the contract in order to interpret these contracts. And I believe that is all I have at this time. I would be happy to address any other questions of this court.
I don't see any further questions at this time, so I thank you for your presentation, and we will move on then to the rebuttal period. Let me stop the clock, clear it, and advise Mr. Norby you have 4.5 minutes remaining.
Thank you, Your Honor. I'll make just a couple of brief points in rebuttal, and of course, we'd be glad to answer questions from the panel. One of the last points that was made by my friend on the other side was that it is not their position that if the gym had never opened, that Fitness International would nonetheless have had the obligation to pay rent month after month. That was an analogy that would, and a question that was raised by Judge Thomas in the 11th Circuit in Miami originally, whether that was their position. It's been disclaimed here on appeal, but that is the only logical conclusion based on their interpretation of the force majeure provision in particular. Their claim is that anything that can be cured by the payment of money does not even trigger the force majeure provision. And so that because the obligation to pay rent can be satisfied by the payment of money, then anything is not a force majeure event unless it specifically prohibits the payment of rent. So I think that is the necessary conclusion that they would draw here. If these orders had gone on for years and years, because the payment of rent can be satisfied by the payment of money, that the force majeure provision would never operate to excuse that obligation from my client. There were some comments made just now on essentially the parole evidence rule, whether considering other contracts would somehow violate the parole evidence rule by looking at the intent of the parties rather than at the language of their contract. I don't think that's the purpose for which the 11th Circuit made that analysis in the case that was reversed by the 3rd DCA, and that's not the purpose for which we are offering the other contract language. It's a different purpose. What we are attempting to show there is that in these commercial lease disputes, it is possible for parties, including the same parties that are at issue in this appeal, to specifically and expressly specify that no force majeure event will ever excuse the payment of rent. And a provision like that is not present in this one. So we're using that as an interpretive guide to show that it can be done clearly, and it wasn't done clearly under this language, and that we offer instead a more reasonable interpretation that harmonizes the second and the first sentence of the force majeure provision and the second sentence of the force majeure provision that gives meaning to both of them, and that also harmonizes them with the contract as a whole. We've cited to the Florida Supreme Court's recent case law on the whole text canon. and how contract provisions, just like statutory provisions or constitutional provisions, should not be construed in isolation from one another. They should be construed in the context in which they are placed in the case of a contract by the parties. And the force majeure provision here is subject to the same analysis. The contract here did not provide for one-sided obligations. It provided for a mutual exchange of obligations in which my client pays rent in exchange for the ability to use the facilities here in the manner for which it was intended in the parties' agreement, under the clear contemplation of both of the parties. Section 1.9 of the lease, I think, indicates as clearly as it could be that the uses of premises here would be as a fitness facility. Provisions 8.1, 8.2, and 8.3 that Judge Casanueva mentioned a moment ago certainly give my client the option to change the use of the facility if it chooses to do so. But I'd submit that's a separate question from what the landlord here is suggesting, which is that my client has an obligation under the contract to change its use entirely from a gym to some other type of business that was allowed to operate in the early days of the pandemics. My client, again, is LA Fitness. We operate LA Fitness gyms, not LA Fitness grocery stores or LA Fitness takeout pizza. That's not what we do. And we also don't operate a facility to store gym equipment. Yes, our gym equipment was maintained on the premises while we weren't allowed to operate, but our business isn't a storage facility for gym equipment either. So whether it's under the force majeure provision or the equitable doctrines, we would ask this court to take another look at the arguments we've made here, if necessary for the en banc second district to take a look at some of these arguments with all respect to the prior panel precedent that I understand binds this panel, or at the very least to certify a question of great public importance to the Florida Supreme Court so that some of these issues which do recur in the commercial lease context and in other contexts could be further explicated by the Florida Supreme Court to provide guidance for the bench and the bar in future cases raising these issues. Unless there are further questions from the panel, I'd rest on our briefs and ask the court to issue relief consistent with our arguments. Thank you.
Thank you. Thank you both. That will conclude this oral argument. As promised in the beginning, after the third case, we would take a recess. According to my computerized clock, it's 11:31. We will resume when my computerized clock hits 11:41. Thank you.